Welcome back. Focusing on the Supreme Petition today, pre-trial conference underway. We are awaiting the decision by the judges. They are expected in court any moment now. I'm still here with Mudomi Thiankolu and Steve Ogola. Steve, I want to start with you. Let's talk about the issue of universal suffrage, because it seems like the boycott of the vote may now be an issue of, in this election, saying that this did not meet the threshold of an election because it did not ensure universal suffrage. Not everybody participated. I
agree. You see, the nature of democracy is that those who govern must get the popular mandate. Popular mandate, although the Constitution seems to adopt a minimalistic approach, because it just says 50% plus one of the votes cast, but then also 25% in at least 24 counties. But you see, if you were to read the Constitution and breathe life meaning to it, what lawyers sometimes call a teleological, historical, and purposive interpretation, then you can enlarge that threshold, because it can't be 50% plus one, where that 50% plus one is 1,000 voter turnout in a country that has 19 million voters. That would lead to an absurdity. There's a level. So I think what that implication, I'm sure the Supreme Court will not be moved easily to accept what Mudomi himself has called in one of his many papers that I've read also, a legalistic and textualistic approach, where it just says that the Constitution says it's 50% plus one, and let's say we take 50% plus one, as it were. I think the court is likely to inquire into the spirit of the law, and in the context where a huge population, a huge section of the boycotted the election, what does it mean in a democracy such as ours that has a post-2010 constitution that is largely described as transformative? What is the Constitution seeking to transform if it is not to inspire national renewal in our institutions of governance? Remember, IEBC, our system is that of inoculation. Inoculating IEBC from external manipulation so that IEBC can operate independently. And there's a presumption in law that if you occupy key independent offices, one, that you care for the rule of law, and two, that you will not let the right-minded walk away thinking that you are either biased or incompetent. Can we really say with certainty and evidence that IBC satisfied the second, or even the first one, that they really care for the rule of law? Because there are some common sense, practical sense issues. Like if you have challenges and you're saying, as Mudomi said, a week to the election, you are telling the whole country in a national address that you have significant challenges in managing the election. One of the lead commissioners, the face of the commission, has had a dramatic resignation, not because of ailment, citing that frustration and saying that the commission is ill-equipped to deliver what may be considered credible. In fact, even before resignation, there were those internal memos, and now you want us to forget those memos just because they were not publicly released?
Yeah.
So the thing is
But they're saying that they were leaked anyway. Would they be inadmissible?
But you see, Yvonne, the thing is this.
They could be inadmissible.
The thing is this. In the context of this is a special kind of litigation that the court must always see, and unlike public interest litigations, the court is duty bound to go beyond what the rules actually say and just bring
so now
life
that it was out in the public domain, I'd like us to
could address that slightly, Yvonne. There are two broad theories of illegally or improperly obtained evidence. One of them, which prevails in the United States, is that such evidence is generally inadmissible. The other general approach, which applies in the other common law countries, including Kenya, is that as long as evidence is relevant, the means by which it was obtained is immaterial. So that as a general legal question, the answer is that it doesn't matter whether these memos were leaked or were published or were not. And actually, the leading case in the Commonwealth on that legal issue emanated from Kenya in the emergency years, a case called Kuruma, son of Kanu. But while tied to that point, it must be remembered that information held by the IEBC is not akin to private property. So it is one thing for me to raid your house and obtain illegally obtained evidence.
But this is in a public
every information that the IBC has is public information. Any property rights in that information is public property.
Okay, let me ask this, because he would have to then come and say that that is in fact not a proper memo, that I didn't write that memo, right?
But you see,
for it to be inadmissible. But so far we've heard him say, yes, those memos were actually factual, but I don't know how they got there. I mean, what if he woke up today and said, you know, I didn't write those memos and those were forgeries, those were fake? That would be a different matter. But he's not saying that.
No, you see, even the courts are also not immune to reason.
Yeah.
And already the evidence that is already in public domain, what was publicly shared, including what is still available on the IBC website, Chebukati's own press statement, is still downloadable, even now as we talk. The thing is this, already there are significant issues around election management that even without additional information to buttress what is already existing, Akombe sent a detailed resignation letter. Later on, the memos were leaked publicly, and now they are public documents. You can't take them away, or even if you recall them, you can't take away what is already documented. So the court must examine the environment in which IBC operated, you know, and be able to satisfy itself that that environment, if the environment was, there was a climate of fear punctuated by election violence, you know, use of excessive force, extrajudicial killings, intimidations to create either voter suppression or maybe voter intimidation, that result in and of itself cannot be described surely as a result that captures the will of the people. The court, in terms of assessment of what election is supposed to return, the election is supposed to return a result that matches the expectation of the people and also meets the requirements under the Constitution. I think, to be honest, IBC will be hard-pressed to explain to the court or to move the court to develop an approach that excuses the court or maybe from examining the environment in which IBC operated. Some of this environment, actually, the law allowed IBC, you know, there's a presumption of competence. And that's why someone like Chebukati, who's the chair, is required to be at least 15 years of an advocate of 15 years of standing as an advocate. Yeah. Article 163, sub-article 6, allows the commission, maybe through the chair, IBC through the chair, to approach the Supreme Court and explain to the Supreme Court that examine with us or allow us to present to you this environment in which you've asked us to conduct the fresh elections.
Okay.
And if it is permissible, enlarge the time to allow us to review and reconstruct the environment so that truly the outcome of that election will be subjected to less litigation or maybe to less doubt. I think they didn't do that. So what they have done is to antagonize the court.
I would like us to, sorry, there's so many things I want us to go through, particularly, you know, those questions for determination by the Njonjo Moe petition. I believe we would have them running on screen so that our viewers can follow with us as we take a look at some of the most pertinent issues in their petition, including the issue of the electoral amendments that, you know, became law during this moment. And Njonjo Moe is citing that and asking the court to discuss whether, or to determine whether they were valid or whether they had any effect on this. Could you talk to us about that, Mathomi?
Well, I've had a chance. I think my views are perhaps the most widely circulated on that amendment bill. My own view has always been every bit of it, except one paragraph, was unconstitutional. And that one paragraph, which was not unconstitutional, was actually unnecessary. But for me, maybe the relevance of those amendments will be on the broader question of the environment. Because if I have understood, and I always refrain from descending into the arena of the politics, it is that one side didn't want those amendments, and the other one was saying, we will have them, come rain, come shine. But then there is something we left. I thought we could also maybe explore further, the leaked memos. Unless IBC is telling us that someone broke into its offices and then stole those documents, if their explanation is they were improperly released, it is actually that contention itself is an indictment on the IBC. You would be saying that my own staff staff are in the business of leaking confidential information.
Right.
And now is somebody who comes into possession of such information. So that, to me, that alone is evidence of a commission that maybe doesn't take its mandate seriously. Because in a properly run institution, confidential memos do not leak.
They shouldn't
leak in the first place. Yes. And if they are leaking, it is actually evidence of that internal turmoil that the petitioners are complaining about.
Commission.
Yes.
Okay, yeah, so an interesting point you raised there. The environment in which the judges themselves are hearing this case. Yes, I want us to canvass so many issues. I'm sorry, but just
sort of one thing that the way I saw the issues just that brought by the petitioners, the lead petition, the pilot petition, Judicial's petition. First of all, the preliminary issue, I call it preliminary advisory, just, I mean, for the benefit of the viewers, the court must first address itself the issue of the consequences of Raila's withdrawal.
Yes.
Because did it have the intended consequence of cancelling the election? Because, you know, IBC, when they gazetted Raila and Uhuru on 5th of September, they gazetted Uhuru and Raila on the understanding that the Supreme Court determination of 2013 allowed them to do so because only Raila had petitioned. The same judgment also recognizes that if you have two candidates as gazetted and one withdraws, then the election stands cancelled and fresh nominations to ensue. That issue has been hotly contested out here, and politics, a lot of politics put into it. But now there's an opportunity to settle it, a very sober, dispassionate approach. Once the court is satisfied that, if the court is satisfied that the consequence of Raila withdrawal was to cancel vacate the elections immediately, then I think if it proceeds to examine the petition, the other issues, it will be for purpose of documenting the challenges, for purpose of making recommendations.
Okay.
But if the court were to say that because of the Ikuru judgment, which will be a problematic argument because the Ikuru judgment came a day after, but nonetheless, if the court were to say that the Ikuru judgment saved the election, then now the election, the petition, the issues will be examined on their merits.
Okay. We've talked quite a bit about the Njonjo Moyo petition, but Harun Mao also has a petition. Steve, what are your thoughts on that? This is not his first rodeo with presidential petitions, as we know. This is a man who's been doing this, you know,
I think
a number of times.
Much of the issues that Harun Mao raises in petition have also been covered by Njonjo. What would call probably now, what the court calls the processual issues in terms of following the law step by step, the illegalities and irregularities. Sort of, if there was supposed to be an election within the 60-day periods, if the court is able to determine that there was supposed to be an election, then the question the court judge is asking, and Harun Mao is also asking, was there supposed to be nomination? That question must be answered. Number two, the irregular inclusion of the printing of Jirongo's name in the ballot papers before gazettement, the inclusion of Raila's name in the ballot. No, that's a separate question from the consequence of Raila withdrawal. Is the inclusion when he had actually withdrawn. You know, he could have withdrawn, but the election was saved. If the court says he withdrew, but the election was saved, but then someone who withdrew and he included him in the ballot, what is the consequence of having a foreign name on that?
Even though IBC argues that the process with which he withdrew
must be examined. That will have to be examined. The issue of changing polling stations without gazettement, that will be examined with full effect. The issue of all these issues of non-compliance with the law will be examined. Then there are also the other issues that deal with the soul of elections. We've said use of excessive force, failure to conduct election in 290 constituencies, you know, opposition election boycott. What do they mean for democracy? You may not be able to reference them specifically in some law, but if you look at them in totality, they implicate the environment in which elections are conducted. So once IBC gets past the hurdle of illegalities and irregularities, IBC and perhaps the extent Jubilee will have to get past the hurdle of now the substantive issues that deal with the election management generally, because election is supposed to maintain the purity of the process as well as the integrity, preservation of the integrity of the ballot.
The judges are hearing this case. This is the second one.
We can talk about that one.
Yeah, because to be fair, and from a layman's point of view, they're human beings. They've been seeing, you know, everything that's been happening. They've been experiencing it as well. So talk to us about, you know, without prescribing how they would make their judgments or what their judgment itself would be, but just talk to us about, you know,
I think of all the Kenyan citizens now living, the most unfortunate are those 6 judges. Because,
unfortunate?
Yes.
Why?
I really don't envy them. And I wouldn't want to be in their shoes right now. I mean, they have been forced in just a span of 1 month to make 2 landmark decisions in a case and in a country where whatever decision they make, it will not be read on its merits. but instead, in all likelihood, they will be profiled.
Yes.
Just like we love to profile our other public officers. This one is this tribe, this one is allied to this political formation. And there is a second reason I don't envy these people. There has been a backlash following their initial decision.
Yeah.
So if they sustain this election, there are people who might think it is because of the backlash. They were called Wakora, they were told they will be fixed, they were told we shall revisit, and those sort of things. And yet, if they nullify this election, they will still invite accusations that you see these people have been hell-bent on working with our political competitors and whatnot. But for me, since they applied for these jobs, knowing the sort of country we're in, maybe the discussion we should be having without, of course, descending into the arena of preempting what decision they should make. For me, every job comes with certain risks. And sometimes the risks are extreme. They extend even to body, limb, and life. The question is, when we write the history of this country, 50 years, 100 years from now, will we be saying that these judges had the long-term best interest of the country at hand, and the decision they made at that time was one that preserved the long-term interest of the country, or did they choose maybe what they considered to be in their own personal best interest? Sometimes when you occupy these very high-profile public offices, you may have to forget your own safety, your own life, and maybe look at posterity and ask yourself, given the situation Kenya is in, and I'm not trying to suggest how they should rule, which decision is more consistent with the long-term viability of the country? And
that's an important one, because talking about public interest, would that at all be at the back of their minds as they're hearing the cases? Like, or will they just be focused on the merits and the arguments that are placed before them, because they don't live in a vacuum?
I think, Yvonne, this time, this particular petition, the judges will make a determination in the context of a challenging environment. Some of these challenges are external to the judiciary, the Supreme Court. Some of them are actually internal to the Supreme Court itself. The ones that are external to the Supreme Court include now there's a discussion, an emerging discourse around public interest. The second one is the hostile the toxic political environment. And the third one is that this election is actually a referendum on IBC, whether IBC was able to capture what the court wanted. Each of these issues have implications. For instance, the question on the public interest. Curiously, it has been framed differently by both NASA and Jubilee. NASA's idea of public interest is that you read the Constitution, and the public interest requires that you bring meaning to that which the Constitution has ordained, because the Constitution is an article of faith. And if it says do this, and the Constitution seeks to improve election management, anything that takes away that which the Constitution has guaranteed, that now offends public interest. Jubilee, on the other hand, says we've already spent 14 billion in this election, and the country is fatigued. Can you make reasonable accommodations that allows the country, that preserves the election outcome, documents the challenges for future learning, and then allows the country to move on? So there's that. It will how judges resolve the question of public interest will depend on their own lenses also. You know whichever way they want to move to that question of public interest. Then also they will also have to examine this time. There's a more poisonous political context, because you see, both NASA and Jubilee have indicated that they are able to operate with outside the law. If you look at Jubilee, they sort of, you could say reasonably they're in this petition because they're defending the win. But if Jubilee delegitimized the court after this, or disregarded the decision, that would not be surprising, because today, early in the day, Madira MP said that for them, nothing short of a swearing in will work. For
But on the other side, they're saying,
wakiapisha, yes. The other side is also saying that there's going to be a grand reception for Raila.
Right.
So then the court will wonder, then, does it really matter that we make a decision either way? Then on the question of the IBC, this election is a referendum on IBC because the court will be examining, did IBC really learn anything or not?
Okay, I think we have to leave it at that. Surely we can discuss this for 3 hours or 4 hours on end. I thank you both, Muthomi Thiankolu and Steve Ogola, both advocates of the High Court. Day 1, pre-trial conference. We await the determination of the 6 Supreme Court judges as to the arguments that have been placed before them since 11 o'clock this morning. Anytime now they should be coming in. But you want to stay with KTN News, we will take you straight there as soon as they file into the Supreme Court. This has been a special edition of The Big Story as we focus on the Supreme Petition. Our coverage of this continues up next with KTN Prime. I'm Yvonne Okwara Matole. Good night.